Good afternoon and welcome to Summary Judgment, a production of American News and Information Services. We are transmitting live from our transmission location in central Connecticut. To my right and to your left is Attorney Rachel Baird, without whom this show would not be possible. My name is Ed Peruta. I'm a legal investigator for Attorney Baird. I'm the president of American News and Information Services. And what we like to do is talk about topics and sometimes take them further than the mainstream media takes them, because we may have some insight into them. So having said that, we're here for about an hour. We could go longer, whatever, but that's it.
A Supreme Court case came out this past weekend that was very exciting to us. I've had clients email me about it. It's a May 17th, 2021 decision written by Justice Thomas about firearms, but really about the Fourth Amendment. But as we've learned in our practice, which does address a lot of firearms issues, when the Fourth Amendment and the Second Amendment collide, usually the Second Amendment is somewhat of a victim. In other words,
An orphan.
An orphan. The standards for Fourth Amendment are higher, it seems, when it comes to anything else but firearms. And I'm going to get in and I'm going to explain that a little bit. So, Ed, the case is Caniglia versus Strom, and it was, like I said, written by Justice Thomas, and it was a 9-0 decision.
Which, to me, is hugely significant.
A firearms decision before the Supreme Court that's 9-0.
Now, you're going to get into this decision.
We're going to talk. That's what we're doing.
So what I would like to do, and I don't think we're going to take any phone calls today, because this is such an important topic to have out there for the people on the other side of the camera, that I don't think we need to be talking about anything but this.
We want to make sure we address it.
Related to this. Now, I made a list, and I'm just going to set this up. We had several male individuals that we were involved with that had items seized without warrants.
Firearms.
Firearms. We had John Doe 1, we had John Doe 2, we had John Doe 3. I don't have to, Joe Kaminsky, God bless his soul, okay? Joe Kaminsky, and we had a female Jane Doe 1.
Which is where
1, 2, 3, 4, 5.
Which is where all this began for us, Ed. That's when we had initially met in 2007, and this arose in 2008, the whole firearm seizure issue. So let's start there.
I had said, all of the statements I heard made in Connecticut, I had said, somebody is going to get these issues, this issue, seizure without warrant, to the federal court system. I said, and I don't believe that the U.S. Supreme Court is going to stand for government coming into your house and seizing items without a warrant, especially when there's no exigent circumstances. It's whatever. But this is what I was waiting for.
The Supreme Court decision,
right,
yes.
Because in my mind, it validates every case we had in your office, I was involved in your office, where we tried to convince the Connecticut State Court that this was unconstitutional. And now, those judges who got rid of it have egg on their, as far as I'm concerned, they have egg on their face.
So let's start at the beginning.
Go ahead.
We had already met and started collaborating on firearms cases back in 2008. We had been brought together by Board of Firearms issues in 2007.
We were brought together by James Goldberg.
The delay in hearing appeals.
Right.
Okay, that's how we were brought together. And so in 2008, when I was contacted by a client who said, the police seized my firearms and I don't know what happened to them. I said, well, where's the copy of the warrant? Well, I don't have a warrant. Well, I went to the courthouse and I said, is there seized property in evidence? In other words, an inventory of seized property? Was it brought by the state police, Troop L? No, we can't find anything. And you remember how I couldn't figure out what happened. how these guns were taken from this woman's home, and I could not track down a warrant to save my life. Now, the guns were taken on May 1st, and for literally a week, I tried to track down the guns. And we could tell that at the clerk's office, there was a little bit of a, you know, chaos, right? Trying to figure it out. Do you remember that?
Yes.
Okay, and so then finally on May 8th, apparently a warrant did issue. And I know you're saying, but the guns were seized back on May 1st. How could a warrant issue on May 8th? And you're correct, because what happened was the guns were seized, and I guess the state police were just going to keep them. But then we started asking questions, and all of a sudden they said, we need to do a warrant. And so they did a warrant under what's called in Connecticut, it's called by everybody a risk warrant, but it's a firearms safety warrant, a firearms protection safety warrant. And they're called red flags now. They're all over the United States, and they've gained a lot in popularity since 2008. Now, technically, the law had gone into effect in 1999. It was a public act in 1999 which allowed police officers to seize firearms when people were in imminent danger to themselves or others, even though no criminal act had occurred. So I think basically for 8 or 9 years, that statute lay dormant, and it was not used often at all. It's used all the time now. So we got involved in that, Ed, and started asking questions.
Okay. In 1999, there was a mass shooting, I'll call it a mass shooting, at the Connecticut Lottery headquarters in Newington, Connecticut. That prompted the Connecticut General Assembly, the House and the Senate and the governor at the time, to pass legislation that we now refer to as the risk warrant statute. If you go back, and Rachel went back 100 times and read the legislative history of this statute, I have to give credit to Richard Tulisano, who's now deceased. He was referred to as King Richard. He was a constitutional scholar in his own right. And there were people during testimony regarding this new law that said it was going to be abused. You know, the slippery slope, so to speak.
Mm-hmm.
And nobody thought that was going to happen. And then you have this guy Lawler. What's his first name? Lawler.
You know, I can't remember.
Yeah.
Robert Lawler, I think.
Whatever.
Yeah.
Who was also a professor in a college.
Mm-hmm.
Okay? And these people enacted and started to use the risk warrant. Now comes Newtown. And, oh, wow, we have a law on the books that lets us seize firearms. So Connecticut started to seize. And some of the opinions regarding, yeah, it's okay to do that. No warrant, just take the firearms and get the warrant 2, 3, 4 days later, a week later, 2 weeks later, whatever, it doesn't matter. And I'm sure that some of those opinions get published and they get thrown around and explained and talked about at chiefs meetings and, you know, whatever. And I said, at the time, I said it to the NRA, I said, Connecticut is ground zero for attacks on firearms because Connecticut was the only state that had a risk warrant statute. Next thing you know, California is enacting a similar statute, but they didn't require 2 police officers. They said anybody can make a complaint about their neighbor or somebody, and the cops can go in and take the firearms. So what happened was, because it had been in Connecticut, quote unquote, it was time tested, okay? No risk warrant had been overturned, so to speak. I think some of you got one overturned on a technicality that they didn't have the hearing within 14 days. But no risk warrant statutes were being overturned in Connecticut. Appeal to the Superior Court or go to court to the hearing on risk warrant? Oh, nope, got to keep them. Appeal it to the appellate court? Nope, state gets to keep them. Go to the Supreme Court? Nope, state gets to keep them.
Well, I mean, there haven't been that many appeals to the appellate court, Ed. At that time,
well,
especially, this was the first. The appeal we made was the first one.
Right, but all it takes is 2 appeals, and everybody sits there and says, "We're going to lose. Why waste the money?"
Right.
Because the precedent is there. Is, well, they got this case and this case. Some people would say at the time, you made bad law, because you appealed it and you lost. Well, you had your crystal ball back then and predicted that this was not going to hold water. This bucket had holes in it. And on May 17th, 2021, the Supreme Court of the United States, in a 9-0 opinion, concurred with Attorney Rachel M. Baird's opinion for the last, how many years?
Because the Supreme Court, in the recent decision, found that community caretaking function is not an excuse, is not an exemption to the Fourth Amendment to allow police to go into homes and seize firearms, or I would suggest for any other reason. That was basically the decision of the Supreme Court this week. I want to go back to 1999 when our General Assembly in Connecticut was debating this new risk warrant law. And there were representatives and senators like Senator Tulisano who were concerned about the violations of people's Fourth Amendment and Second Amendment rights. At that point, of course, the United States Supreme Court had not yet decided that the Second Amendment guarantees the right of individuals to bear arms. But the Fourth Amendment was certainly a huge concern back in 1999 when they were advocating that even though a crime hadn't been committed, the police should be allowed to go into people's homes and seize firearms.
Because we care about the community.
And this is what one of the drafters of the bill said, along with, I think, is it Richard or Robert Lawler? I think it's Richard Lawler, who drafted the bill, the firearm seizure bill, and was trying to defend it against people that were opposed to it on constitutional grounds. And this is what the Representative San Angelo said in response to people that were questioning this bill. He said, Representative Lawler and I worked very hard in redrafting and redrafting and redrafting that section to bring out the concerns that people had. It is now police officers who will have to do a full investigation before they could ever go to the judge. That never happens.
Hey, can I say something?
I'm sorry, that never happens.
A full investigation is not cut and copy from a previous warrant and paste it into this one and say that's what happened.
A full investigation does not leave out the fact when you're trying to prove that somebody poses a risk of danger to themselves or others, the fact that they were at a hospital and a doctor released them saying they were not a danger to themselves or others, and they leave that out of the warrant all the time. So what kind of full investigation is that, Ed?
Well, okay, but let's, for argument's sake, this is for argument's sake now, we're going to say you can seize the firearms today and you can get the arrest warrant in 4 days. Okay, so you have that period of time between the seizure and the signing of the warrant, right? You sent the man to the hospital when you seized. You put him in the back of an ambulance. It was an emergency commitment order. He goes to the emergency room. He's examined by doctors. And they go, there's nothing wrong with you. Go home. Now, when the officer, and we had one that said, I'm the report writer, I'm the guy that writes everything to make it correct. They, law enforcement, failed to put into the warrant, and he was such an imminent danger to himself and others that the hospital, after medical examination and psychological examination, sent him home.
Allowed him to walk home.
That, to me, is exculpatory information that was not put in the warrant. And you can't say you didn't have the time. I mean, it was like it was yesterday, Rachel. I can remember. You want to get a risk warrant? You at headquarters in Middletown. You drive
Oh,
past
wait.
the Middletown courthouse.
This
past,
is another case. Yeah, go ahead.
No. But it was a warrant. They didn't have a warrant. They drive right past the courthouses on the way to the house in northwestern Connecticut, okay? While the individual's locked up in a hospital, but they go right past the courthouse and seize the firearms. Why didn't you stop in and have a judge sign a piece of paper?
Yeah, so go back to 1999 again,
Yep.
and this representative continued saying that the police would have to look at it. As Representative Lawler quite correctly pointed out, they will have to look at every other possible alternative before they can even go to a judge. In other words, before even going to a judge to get a warrant to take somebody's firearms, the police would have to look at every other reasonable alternative. And you know what one of those reasonable alternatives is? Having the person go to the hospital to be examined. So I argued back in that case in 2008, the person did go to the hospital. There was a reasonable alternative. So how do you go and get a warrant when the statute says if there's a reasonable alternative, then you need to do that instead of getting the warrant? The warrant is a last resort to taking somebody's property when they haven't committed any criminal act. Okay? And the standard is set extremely high.
Yeah.
Imminent danger to himself or to others, which means that he has to be getting ready to either kill himself or kill somebody else.
He's got his finger on the trigger.
I've never had a case where danger was imminent like that. Never, ever, ever.
No.
Have I had a case?
There have been, but not in your law practice.
Have there been?
I'm sure that there have been situations where there was threatened violence. They may have a hostage situation in a house, okay? And
But those people get arrested. Those are criminal acts.
right, but okay.
Yeah, what do you think?
I can't help but be extremely frustrated sitting here today,
Well,
listening to what was said prior to the bill becoming law, and listening to what those people were talking about, and then once the law passed, they completely ignored
yeah.
their own predictions.
Going further, and we've set some of the things that the judge has to look at. Again, they're very high. Believe me, they have not been very high at all. You have to have firearms in your house. You have to be brandishing them. That's not true. That's not how it's been. I believe that any reasonable judge in the state of Connecticut will be extremely cautious in putting this provision forward. No, the opposite is true. Judges are extremely cautious in denying a warrant because the thought in their head is, what if I deny this risk warrant and the next day it's in the newspaper that something happened? I got to protect myself, correct?
Yes.
I believe that any reasonable judge in the state of Connecticut will be extremely cautious in putting this provision forward. We'll look at it very closely for absolute purposes of legislative intent. That's a lie. It makes absolutely clear that this is not to be used very often. Yeah, it wasn't used very often until, in this case back in 2008, was appealed to the appellate court. The appellate court said, you know what? It's okay. Just go in and take the firearms. You don't need a warrant. And then once you get them to the evidence room, at your leisure, do a warrant, okay, to seize them from the evidence room. And then you're all set. Once our appellate court made that decision, yeah, they started to be used quite often.
And I believe that credit has to go where credit is due. Michael P. Lawler.
Oh, thank you.
Got it? No, I don't want some other Lawler to get the credit for this. I Googled him. You know, it's Michael P. Lawler. Okay? And he was one of the people that was assuring the public this would never happen. This could never happen. This won't ever happen.
The law makes absolutely clear that this is not to be used very often, but only in very rare, extreme situations. That is recognized by everybody that's a proponent of this amendment.
Do you know, I consider myself to be right of center now. I'm not on the liberal side of center. I feel like I'm conservatively reading and feeling the freedoms that we get from our Constitution.
Well, okay, we don't want to upset anybody like Gary Nance out there. Let's specify that. We don't get freedoms from our Constitution.
Okay.
The Constitution
Yeah, but you know
guarantees
something?
our
I
freedoms.
may say it wrong, but everybody knows what I'm thinking.
Exactly.
I
got
don't
it.
even need a fucking Constitution. I know what I am entitled to do and don't do. Right and wrong. You know, but somebody felt that they had to put it in writing way back when, okay? And I've often said that, for example, in the Connecticut Constitution, the right to keep and bear arms is not there. The federal says keep and bear arms. The Connecticut Constitution simply says bear arms because keep was a given. Everybody had to keep one. Everybody was keeping one. So what I'm trying to say is this, is that I am extremely emotional when it comes to this topic because I know in today's world in 2021 how difficult it is to see a 9-0 decision out of the United States Supreme Court. There's people that are sitting there saying, we have to stack the Supreme Court because they're not making good decisions. We need to have the liberals. The liberals joined. You know why? Because even a radical left-wing Antifa has the right to be protected in their home. I just got done saying to a group of people, okay, that I've seen castles in Europe. I've been to Europe. You've been to Europe. You see the castle on the mountains in Europe, especially in Germany, Austria, places like that. Okay, I may not have that big stone castle up on the hill, but my little 900 square foot house or condo is my castle. And that was the whole theory by the Fourth Amendment. How hard is it to understand? Do not come in my house without a warrant. Now, you know that they play all kinds of tricks. Gorsuch was before he got appointed a justice of the Supreme Court, one of his pet peeves in his writings as an appellate judge was this permission to come in the house is being used and abused.
Consent.
This consent thing is being abused. You know, let's take, for example, and I don't know how to say this politely, a person who has mental deficiencies, but is astute enough to be able to survive in the world, drive a car, but he's not the brightest light in the room. And the police come up and get into his house because of trickery, because of words that he doesn't understand, or he doesn't understand how it works. He didn't pay attention, or it wasn't something, he was trying to survive, not read the finer points of the Constitution. This decision, in my opinion,
Which we haven't talked about yet, by the way.
I'm going to be done. This decision, in my opinion, is a bellwether, a signal, the canary in the coal mine for that New York CCW case that's coming up. Because I've said for years now,
Good point.
the articles in the paper say a shooter shot a whole bunch of individuals. But it should say an armed assailant shot 12 unarmed people. If there were 12 guns in the church or in the movie theater, the outcome would possibly have been different. Now, go and talk about the way you talk about laws.
Well, no, I'm going to start going through the facts of this case because it's a very, very brief case. It's amazing. It's amazingly brief. So Justice Thomas begins, and go ahead and comment as we go along. He says that
My man, Justice Thomas.
decades ago, this court held that a warrantless search of an impounded vehicle for an unsecured firearm did not violate the Fourth Amendment. Okay.
Yeah.
That was a 1973 decision.
Yep.
In reaching this conclusion, the court observed that police officers who patrol the public highways are often called to discharge non-criminal community caretaking functions, such as responding to disabled vehicles or investigating accidents, right?
Right.
The question today is whether that decision's acknowledgement of these caretaking duties creates a standalone doctrine that justifies warrantless searches and seizures in the home. It does not. I get chills because the way things are in Connecticut, it certainly does. For years now, you have said, Ed, that when the Supreme Court comes out with a groundbreaking decision, that states and the feds, I guess, but we're interested in Connecticut here, and wherever you live, I'm sure you're interested in your state, are the states going to review their laws and say, do the laws that are currently in place, such as our risk warrant law, violate this decision that the Supreme Court just issued? I think our risk warrant laws in Connecticut do violate this decision, at least insofar as they're carried through with, and that is, we do warrantless searches all the time in Connecticut for guns. And then they do the warrant later, justifying the search that already happened. Go ahead. No, that's your theme that you've carried forward all these years.
I have
You know
said,
what? We need to go to that police accountability board or task force or whatever the hell it's called now that they just made because of, everything that's been going on with George Floyd and everything else. We need to go to them and say, you need to review these risk warrant laws because of that decision that just came out.
What's the date number? 21?
22nd?
20, whatever.
May 22nd.
So it's 7 days since this decision was published. Is it called published?
Monday, yeah, it came out.
Okay.
Yep. What is it called? Issued, published? Decided.
Decided.
It was decided.
It was decided, and they made it public on the 17th?
Yep.
Okay. I'll bet anybody $5,000.
Oh, boy.
I'll raise it to 10.
No, lower it.
That there's at least one police officer on the front lines of a police department who has not been made aware of this decision.
You're right about that.
That's a good bet, huh?
Yeah.
That if you walked up and asked somebody, I was talking to somebody the other day, and I can't say who it was.
Yeah, don't say.
But I was talking to somebody, the person was in law enforcement, and, you ask them a question, and they give you an answer, and I said, you're wrong. You're actually wrong. And let me tell you why. And then you cited Supreme Court decision. Well, I didn't know about that. I said, well, you should, because we have situations in Connecticut where the verbiage of the law is extremely clear, and they overturn it in a legal decision, but they don't rewrite the law to match the judicial decision. In other words, if the Supreme Court says, or if an appellate court in Connecticut says, that risk warrant, that's all fucked up. It's got to do this. Every police officer, it's going to be a whisper campaign. Hey, you know what you do? You do this, 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 and this, and we'll get past it, and nobody will give it. But they don't change the law. So the person who's unaware of that situation and that court case simply goes to the law and reads it and says, I can do that. And then they find out they can't. I'm sorry, but...
Okay, so let's keep going.
Keep going.
So this is a description of the facts of the case in the decision.
I think it came out of Rhode Island.
Yeah. During an argument with his wife at their Rhode Island home, and I'm going to tell you, we had a case exactly like this, 2 cases. Edward Caniglia, petitioner, retrieved a handgun from the bedroom, put it on the dining room table, and asked his wife to shoot him now and get it over with. Okay. It's not funny. It's not
No, it's
funny
not.
at
You
all.
know,
but I got to tell you,
in a marital relationship,
a lot of us know people that have done
in
this.
a marital relationship, maybe you don't have the gun. Because, well, why don't you just shoot me and put me out of my misery now? You know, because I can't handle this anymore. Just shoot me. Okay? I mean, I'm on my 3rd marriage. I went through 2 marriages where, damn, shoot me. Put me out of my misery.
Okay, so his wife declined.
To shoot him.
Right.
Yeah.
And she instead left to spend a night at the hotel.
Yeah.
The next morning, when the wife discovered that she could not reach her husband by phone, she called the police and requested a welfare check.
She was concerned.
Right. So the police did accompany the petitioner's wife to the home, where they encountered petitioner on the porch, and I'm just going to call him Mr. Caniglia.
Hold on. Point of order.
Caniglia.
Point of order.
Yeah.
They met him on the porch, which is outside the home,
Yeah.
not inside the home. But keep going.
Yep.
That's the first thing I pick up.
Caniglia spoke with the police, and he confirmed his wife's account of the argument,
Yeah.
but denied that he was suicidal.
Yeah, that was yesterday.
Maybe tonight, yesterday, but not right now. The police, however, thought that he posed a risk to himself or others, and they called an ambulance, and he agreed to go to the hospital for a psychiatric evaluation.
Bye-bye.
But only after the police promised not to take his firearms. So he did not consent to his firearms being taken.
He did not.
But once the ambulance had taken him away,
This is a
they
different
seized
story.
the firearms, and guided by his wife, whom they allegedly misinformed about his wishes, police entered the home and took 2 handguns. That's an interesting point. So the police told the wife, oh yeah, he said we could go ahead and take the firearms. Because you know, there are cases now where the husband and wife are there. Let's say the 2 owners of the house are there, or the 2 people that have an interest in the home are there, and one says you can come in and the other says no. So they arrest the person that says you can't come in, take him away, and then the sole person who's left says, yeah, you can come in.
The yes half of the relationship is in charge of the property.
Now, if the police had told this wife, yeah, he said we couldn't take his firearms, but we're going to ask you, can we take his firearms? And she said yes. I don't know how this case would have worked out. It could have been different.
Well, no, whoa. There's not 2. When I buy a firearm in Connecticut, I have to fill out what's called a DPS-3 and all of this paperwork that I own the firearm. Did you know you can't put 2 names on the ownership of a firearm?
Yeah, but firearms exist still that aren't, on any records with the government.
Right, but I mean,
and who knows whose guns they are.
The question is, does a wife have the right to surrender my firearms?
Well, I mean, you have a couch in your house. Whose couch is it?
Right.
You or your wife's?
Right.
So you have a firearm in your house. Whose firearm is it? You or your wife's?
Well, if I bought it, look.
I know. It's a tough one.
You know how you can tell you're in trouble when you're married? This is just to liven it up a little bit.
Well,
when your spouse goes grocery shopping and comes home with little bottles of ketchup, little bottles of mustard, little bottles of laundry detergent, and she's not buying for a month. She's buying week to week. Or she's buying all kinds of clothes that you can't wear. So that when the division of the marriage comes up, she gets to take all of her clothes and you get to take your clothes. And no, I'm just telling you that this is absolutely crazy.
A little off
can't
topic.
give away. But you can't give away my firearms. You do not control my firearms. Period. You don't control it. It's mine.
let's assume, for the sake of this argument, that the firearms were his. Yeah, that there's some sort of paperwork or history which shows that they're his firearms. Because that's what the court based its decision on. If they were the wife's firearms, then there'd be no problem.
No problem.
Okay. Mr. Caniglia sued under 42 United States Code 1983, Title 42, 1983. That's the civil rights where you're allowed to bring claims that there was a constitutional violation. He said they violated the Fourth Amendment when they entered his homes and seized his firearms without a warrant. What do you think the district court did with that?
Threw it out.
Threw it out.
Who do you're crazy.
And I think the district court in Connecticut would have done the same.
Absolutely.
Okay. You've been,
and I'm gonna tell you
you've been encouraging me to bring this kind of case for years, Ed.
I've been
will
telling
admit
you
that. And I've told you, I've said, it's going to get thrown out in district court. The Second Circuit's going to throw it out. And I don't have
the resources
to carry a case like that to the Supreme Court. You know who took this case to the Supreme Court? Let me tell you. A huge New York law firm. Skadden Arps, Slate, Meagher, and Flynn. Look it up. It's huge. It's an international law firm with offices all over the world. Probably has 1,000 attorneys in New York City, and that's not the only law firm that took it up. Okay, that's what was needed to get this case to the Supreme Court and get it heard. I'm sorry.
You know,
and I knew
if
that.
I've said it once, I've said it 20 times on this show. I had an opportunity to shoot James Edward Carpenter in the back, running away from me in the third week of October, 1971. I pulled back and I didn't do it. I had to wait until 1984, I believe, for the Supreme Court to rule in the case of Gardner v. Tennessee that you can't do that.
And so you were right not to do it.
I felt vindicated that I made the right decision, even though I got written up for it, okay? Mishandling of a prisoner. Now, when I heard that it was a 9-zip decision regarding seizure of firearms without a warrant in a home in Rhode Island, the next state over.
Blowing away this made-up community caretaking bullshit.
I sat there and was able to take a very deep breath and relax and say, Rachel is now vindicated. I don't know how she's going to feel.
And a lot of other frustrated attorneys.
No, but I'm saying I saw your frustration trying to expose a Fourth Amendment violation by law enforcement that was happening regularly. And I believed at the time that the frustration you had affected you to your very soul, because we knew. And the Supreme Court vindicated your work, your thoughts, your opinions.
Well,
9-0.
We haven't heard that part of it yet.
Okay.
Okay, so where were we, Ed? Oh, the community kid. Okay, so the district court threw it out on what grounds? Oh, I thought we had our summary judgment sign up. They threw it out on summary judgment. We don't have our summary judgment thing up. So they threw it out on summary judgment. For any of you who don't know, summary judgment is a process where each side makes their best effort to put in their case in paper format, the evidence, affidavits, any exhibits they can put in and submit to the judge. And the judge sits there and reviews everything in his or her chambers and says, no reasonable jury could find for the plaintiff. No reasonable jury could find for Mr. Caniglia. So you know what? I'm going to throw this out because it would be a waste of time to let Mr. Caniglia go to trial.
I wanted to ask you.
It would be a waste of everybody's time.
I have a legal question.
Yeah.
How many jurors would he be entitled to if he brought this case and wanted a jury trial? 6 or 12?
Well, it does vary. I believe it would be 6.
Right. Well, he had a jury of 9.
Right.
So no judge can sit there today and say, there's no jury. Because all you got to do is find 9 like-minded people to sit in the jury box and listen to the story. That fucking ship has sailed. You can't find a jury. Even summary judgment. I think summary judgment is going to be attacked by this court.
Oh boy, summary judgments like qualified immunity, they're so ingrained in the operation of the court system, federal court system, state court system too, that yeah, that's going to be a tough one.
See, here's what
Let me keep going through the decision though.
Go ahead.
Okay. Throwing that on summary judgment. Citing the Supreme Court statement in Cady, C-A-D-Y, which is that decision from 1973 where they said the community caretaking function applies to vehicles in that case where there was a unsecured firearm in the impounded vehicle. So the first, citing the court statement in that case that applied to motor vehicles, that police officers often have non-criminal reasons to interact with motorists on public highways. The First Circuit extrapolated, which means they took from that motor vehicle case and applied it to this case involving the home, a freestanding community caretaking exception that applies to both cars and homes. So if the police are out, if somebody calls the police and they say, I'm concerned about my neighbor's welfare over there, okay, let's just go right in. Community caretaking, it's our job to take care of the community. You know what? Number one, you're in your home at that point. I'm not so sure that's the community. But in any case, accordingly, the First Circuit saw no need to consider whether anyone had consented to respondents' actions, whether these actions were justified by exigent circumstance, or whether any state law permitted this kind of mental health intervention. All that mattered was that the police efforts to protect Mr. Caniglia and those around him were distinct from the normal work of criminal investigation, fell within the realm of reason, and generally tracked what the court viewed to be sound police procedure. And so the Supreme Court granted cert to hear this case. Interesting, huh? That they granted cert on that case, Ed.
And it could be because it was so brief and so clean.
Right.
The issue had no... Here's what that case is about. Life. Relationships. Very few people that I know can be married for an extended period of time without having situations similar to what occurred in that relationship in Rhode Island. And I would be remiss if I didn't say, why don't we find out if they're still married and living together? Not that that means anything.
This reminds me of a terrible case we had in Eastern Connecticut where, very similar to this, the man was frustrated. He had found that his wife had been not paying the bills with the money that was supposed to pay the bills. She'd been hoarding it away along with all the bills in the garage, planning to divorce him. Very religious gentleman, and this woman, and so they're behind on all their bills. She's planning to divorce him, all this other stuff going on, and, he's a guy that just goes to work every day.
And
right?
Church on the weekend.
And church on the weekends, right. And so when he found out, they got into an argument. It did not involve guns in any sense of the word, and she left to go stay with a relative or a neighbor, somebody far away, and she called the police, and the next day, she wasn't even at the house. The police went to this gentleman's home. I swear, they must have took firearms that were worth a couple $100,000.
Right. He was a collector.
Rare firearms. Crazy. Not to mention boxes and boxes and boxes of ammunition, meticulously kept, firearms magazines, and of course they wrote this up. This man had no record. God-fearing man, went to church on the weekends, no record, but they painted a picture that he was just a nut. A nut. Oh, and he had gun magazines from 1950. Yeah, he collected them, and they were in immaculate condition.
But
I don't want to get away from that story. Let me tell the ending of that story. His case was dismissed. Breach of peace, some bullshit domestic thing, dismissed. But he never got his firearms back.
he had to sell them. He didn't have anybody to DPS him. He had some firearms that he had the right to own, but he didn't have the right to transfer.
Right.
In other words, I'll say it. He had 2 M60 machine guns in the basement, okay, which were Vietnam-era collectibles. In other words, what some people can't understand, and I've heard you say it a dozen times, oh, what does he need all of those firearms for?
No, I don't say that.
No.
I don't say
Somebody
that.
says to you, why does your client have all of these firearms?
Well, no, it's
and
not.
then you come back
no,
and say,
no,
why
no.
does Jay Leno have all the cars?
It's not just somebody that says that to me. It's judges that say it.
Yeah.
It's judges
But
that
why
say
does
it.
Jay Leno have all those cars?
Right. I don't know why. I don't want all those cars.
But I got to tell you something, and I've said this before. I said it when I spoke out in Ramona. You know, there's different types of people have firearms for different reasons. Okay. And one of them is as an investment. We had someone come into the office who had a World War II Thompson submachine gun, like you see on Elliot Ness and the Untouchables. You know, the 1920s Vert type of machine gun. The 101st Airborne jumped with them into Normandy, the Thompson submachine gun. His was a Navy version.
I don't want to go on screen.
Worth 70.
I don't want to.
Worth $70,000.
Uh-huh.
And you know, he had the red. Okay. Some firearms are extremely collectible and worth a lot of money. One handgun can be worth a lot of money. We live in troubled times, and I believe that this Supreme Court is going to look at the concealed weapons permit laws in New York, and they're going to really come down hard on gun restrictions. You either change the Constitution or permit honest people from having, you got to let them have firearms.
I was trying to look up and see on what basis this case is. How old is this case that we were just talking about? And I'm going to get
Which one?
I'm going to get this information from our viewers. It's from 2014, and I hadn't thought about it before you made a list before the show. I can't remember why they kept his firearms. Sitting here right now, I can't think of a reason why they kept his firearms.
Oh, well, there's another case out of California where they seized his firearms. Then they were supposed to give them back, and they go, "Oh no, we're not giving them back till you get a court order." We've had that.
But this case, I can't remember. It's been 7 years, and I gotta refresh the record on that, because I'm sure a lot of people who are listening are like, "Well, if they dropped the case, why didn't he get his firearms back?" So we got to follow up on that. Okay, back to the Supreme Court case of Caniglia versus Strom. So, to be sure, the Fourth Amendment does not prohibit all unwelcome intrusions on private property, only unreasonable ones.
We had a client, Joe Kaminsky, a Marine Korean War veteran who lived in a little house in Connecticut on a lake. And he was so proud. You know, he sits in a chair and the blanket is the Marine Corps emblem in back of him. He's got Marine Corps memorabilia all his house. He's proud of the fact that he served as a United States Marine. And I got to tell you, of all the branches of the service, the most rabid ones for feeling connected to their branch of service, Marines probably take the cake. But there's a judge.
Well, you're biased.
Because I'm an ex-Marine, or I'm a former Marine, or I'm whatever. Yeah. There's a judge that made a decision that law enforcement was invited onto his property because he was flying the American flag. One of the reasons why government could come on the property is because he was flying the American flag. Are you kidding me? Are you kidding me?
And because it was such a large pole that you could see, he lived on a lake.
Yeah.
and the flag was so big, it was an invitation to attention, so therefore he could not expect privacy.
Right. Right.
I think
God rest his soul. He fought right up to his last breath.
he did a week before he passed, and I think he was about 87 when he passed.
Yeah.
A week before he passed, thank God. Maybe it was only 4 or 5 days.
You saved the phone call.
Yeah, I saved it. Well, it was a voice message, and then he also called, and we happened to be right there, Ed, and both of us were there. And he was asking me to pull out paperwork because the state police were messing with him again. And they would send him a list of his machine guns, and the list would always be wrong. And and it would frustrate him to no end.
They threatened this man with all kinds of criminal charges, and he held up his bottle of medication for a terminal illness and said, "What are they going to do to me? What are they going to do to me?"
He's the gentleman that had a conviction from 1946 for unemployment fraud. Was it 46? 64, I'm sorry. 1964. He was out of work, getting unemployment, but then he was doing some side jobs as an electrician. Him and his wife got in an argument, and she turned him into the police. They reconciled after that, but...
he took care of her in a nursing home up until her death.
And he actually did some jail time for that, and it didn't involve a lot of money, I think $300 or $400. But anyway, it was a misdemeanor when he pleaded to it. But then all of a sudden in 2011... Detective Barbara Matson from the firearms unit gets her hooks into some communication from somebody
ATF.
That this is a felon who has FFL and a permit to sell, and you know he's had these things for decades. And they go out to the house and they take all his guns. Turns out he wasn't a felon. It turns out they were looking at a statute from much later where the same offense became a felony, but when he pleaded to it, it wasn't a felony. And if she had just asked a judge for a warrant, maybe a prosecutor...
And drove by 7 courthouses on the way to his house.
Maybe a prosecutor who is a lawyer would have said, wow, that's an old charge from 1964. How did he get away with this for so long? Could something have changed? Because they do amend statutes. Let's look at the legislative history of this statute and see if there could be a mistake going on here, you know? And if the prosecutor didn't think of that, maybe the judge would have thought of it. That's why you go through the warrant process, because police officers don't know everything about the law, correct?
That is absolutely correct. I've had an opportunity to speak to a couple of police officers in the last month. And I asked them, because we were talking about firearms, and I had firearm questions. And I asked them, I said, because I went down to the Connecticut Police Academy, to Chief Flaherty, who was the executive director, and I said, can you give me your syllabus, what is it called, the syllabus, your lesson plan?
Yes.
That you teach administrative firearms law to your officers? They came out with like 3 pages of laws. And so I said that to these police officers. I said, look, you're not trained. I said, I'll give you an example. In the state of Connecticut, the law only permits the state police to seize your permit. A local PD can't do it. But they do it every day. Community, whatever it's called. It took an act of the legislature to give law enforcement permission to take your driver's license when you're falling down drunk driving a car. They had to enact legislation to give people, an officer, the right to take your license for 24 hours. They've never passed a law giving local law enforcement the right to seize a pistol permit. And now that community standard shit is going to fall right down in their lap the minute you take somebody's firearm permit, their pistol permit. It's going to, same thing. Going to sue him. 1983, he had no right to take his permit, only the state could do it. And maybe after you file a lawsuit, the state's going to take it, but you know something? Too bad, you fucking violated his rights.
And just a side, I think I remember why this gentleman's guns were sold. I mean, they were sold. It's not like they just took them and there was the divorce action. So this was part of the divorce action, the disposition of the wealth or the value of firearms. I'm pretty sure that was it.
They wanted him to not possess any firearms. They knew that his permit had been revoked. They knew that he didn't have the right to buy a firearm without an eligibility certificate, that he would have to acquire them by purchase, and he couldn't get them anyway unless he had an eligibility certificate or a permit. They didn't want him to have the firearms, and he had to sell them to an FFL.
Yeah, it was part of that. Okay, so anyway, let's keep. We're going to be going on longer than an hour. I mean, we just have to. Ed. We have to.
Okay.
We have to get through this case.
Then what
That's why I didn't
what I want to do is this. I want to stop at an hour and then start right back up again, because I want to be able to put this out to distribute it as a 1 hour program.
So this is part one.
This is part one.
Okay.
This is part one.
I'm
So
in agreement
as far
with
as
that.
I'm concerned, Master Control can end it right now. Okay.
We
No,
still
no.
have 4 minutes
Okay.
anyway. So yeah. Okay.
Alright.
So I'm going to keep going. So there are exceptions to the Fourth Amendment warrant requirement, even
Absolutely.
for entry to the home. Number one, the one that's used most often is consent. Because people, when police officers come to their home and want to come in, I'm sorry, most people say yes. I don't care if they've got a dead body in the living room. For some reason, people say yes.
Let me give you an example without naming names. A firearms owner owns firearms, and the local police department is walking up to his door. This gentleman has a son who's a member of law enforcement for some other department, state police. He's thinking that a contingent of officers are coming to tell him that something's happened to his son on duty. May we come in? Absolutely, come on in. Okay? Oh yeah, well we're here because, and, we're going to take your firearms. That's when I talk about trickery, or, you're walking up and here's what he's thinking, that my son, something's happened to my son. Or, how many times do you see the television, the military notification detail parks the military car in the front of the house, and an officer gets out in his full dress blues and he's walking up to your door, and you have a son in the Marine Corps in combat. What are you thinking?
Well, and in Mr. Kaminsky's case, he was a longtime resident of the town, knew the local police officers, and so when the state police came, Barbara Matson and other members of the firearms unit, who they brought along a local police officer that had a good relationship with Mr. Kaminsky, and that's how they wheedled their way in to say it was consent.
Look, do you know how many times I sit at home?
So they do plot. They do. They absolutely do.
Somebody writes the scripts for Blue Bloods,
Well,
NCIS,
yeah.
and all this. And there's times I'm yelling at the TV, saying, "Don't let him in the fucking door! Don't let him in the door! Tell him to wait outside! Don't come in!"
Well, and how about that case where it wasn't a firearms related case, but I said to the officer who went to the house and got a confession out of the woman, a written confession, that she later wanted to recant. I said, you went there for one reason and one reason only, to get a confession. And he said, yes. I said, not the truth, right? Just a confession.
And the ironic part is, okay, somebody comes into my house and say, something happened at work the other day and we're trying to figure out what happened. Do you mind giving us a statement? Oh no, I'll tell you what happened. And next thing you know, you're under arrest. When did they fucking read me my right? In other words,
they don't have to.
You knew.
They don't have to.
They knew going to Joe Kaminsky's house
We got to
when
stop.
they left the state police.
Yep.
Okay, stop. Part one, suspense. Ready for part two.